Welcome back. Okay, so we've been talking about the heat all week, and I guess apparently
all summer.
All summer. We're not going to see much relief until what? The end of the week of this new work week?
Yeah, and I mean, we're talking like slight. Listen, I love the background on this graphic. That's where I want to be all day, every day. I don't really like the numbers coinciding with it, but that's okay. You know, near 80 degrees at 8 a.m., that's totally fine. Not hot at all.
Is it?
There's still about a 10 to 20% chance of those bubble up thunderstorms during the afternoon that fade away with sunset. And then we get that relief. We're still looking at 90 degrees. It's still going to be hot, but it won't be quite as humid. So if you're headed out to a Trash Pandas game, I would say Wednesday is looking absolutely beautiful for that. So at least, you know, no wet weather to spoil any of those games. Really hot this weekend. Maybe some substantial rainfall next week.
We can only hope. Yeah. Thanks, Lauren. Thanks, Jim. WAAY 31 gives you 24/7 coverage. You can count on local news, breaking news, and severe weather. Don't go anywhere. LawCall is next.
This is WAAY 31 LawCall.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight, it's Grandpa in the Law night in honor of Father's Day. Happy Father's Day to all the fathers out there. We're talking about taking care of your parents and times when parents are getting a little older and maybe you're having to plan, you and siblings having to plan, or maybe you and siblings disagreeing about what to do with your parents. Some tough decisions to make. You may have questions about assisted living facilities. You may have questions about powers of attorney, wills. What happens if somebody passes away without a will? Tonight's your chance to call in your questions or text your questions. That's our new thing. So you can call in or text your question to 256-536-0077. You can also email a legal question any day of the week on any legal topic. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we pull some out. We've got some of your grandpa in the law, estate planning kind of questions tonight. So getting us started tonight, Michael Timberlake's here from Timberlake, League and Brooks.
There you go.
We always like to start off while we get our questions locked in with some video. So we pulled some video for you tonight from YouTube.
All right.
This video, so we talk about car wrecks a lot in our show, but this time it's a scooter incident.
Uh-oh.
Okay, so watch what's going to come in the door. This gentleman seems to lose control. Maybe he can't find the brake. So he's got to be responsible for some of what's going on with the scooter there, but the thing with the door, maybe as a personal injury attorney, you see something different with that.
Okay,
what
so
do you make of it?
Yeah, kind of one of the things, first thing you look at is, okay, what is his experience on this type of scooter? Is it his? Does he know how to operate it correctly? Or did it malfunction in some way that caused this problem? So that would be the first thing you look at. The second thing you look at is the manufacturer. If there's a product malfunction or a defect, that's something you could look at. If the scooter was supplied by the store,
yeah, that happens a lot.
You see that a lot of times. You're like, I always question whether that's a good idea to provide the electric scooter to somebody.
Do they
that
test
may not
them?
have training, and may not, so it's really kind of a dicey situation. But in general, looking at the video, it doesn't look like the business did anything to invite the scooter incident, but the operator certainly could be responsible.
Okay. Tonight we're taking calls and questions about grandpa in the law. So we're talking about estate planning, wills, powers of attorney, things like that. And you've got a great guest with you tonight. Zach Anderson's with us.
Zach Anderson's with us. He's been practicing in Huntsville for about 6 years. Graduated from the University of Alabama as a fine attorney and is friends with Sharon's family. So we're glad to have him on.
Known Zach forever. And he's got his own office. You are now Valley Estate and Elder Law. So you do all kinds of elder law, estate planning, and for younger people too. It's not just necessarily for older people. You've got a younger adult kind of package or something you offer. What do you offer to younger adults?
Absolutely. So the factors and things that are going to be more important is going to be based on your age. I like to say everybody has an estate plan. Something's going to happen with your assets if something happens to you during life or when you pass away. It's just a matter of what is it, and the plan that the state of Alabama has for you is probably not the one that you like. So that's kind of the way we like to put a little bow on that.
Yeah.
What are the basic estate planning documents everybody ought to have?
Sure. So some of the more basic documents, most people are familiar with a last will and testament. That controls assets that are owned in your individual name at the time of your death if they're not owned jointly with another person or perhaps in trust or something like that. A financial power of attorney is what I like to call the best bang for your buck. Estate planning you get, those are immensely powerful, and as such, they should only be granted to trustworthy people who can do the job. A healthcare power of attorney is just like a financial power of attorney, but covers healthcare matters should you not be able to do it. We like to handle HIPAA as well, just very briefly, making sure that your agents can get your medical information.
Gotcha, because there are very strict rules that medical providers are not supposed to hand over your personal medical records to anybody unless you've signed something to let them have that, even family members, right?
Yeah.
Even family members.
Okay, we got an email question in from Bob. Bob has written in saying, do I need a lawyer to create a valid will, or can I use one of those kits that I see online? Would one of those hold up in court? Certainly cheaper sometimes.
It is cheaper. And so, one of the things you look at is, okay, do you need a lawyer? Well, maybe you don't need a lawyer to tell you how to do a will or what you want to do with your property. But you need a lawyer to make sure that the format that you've provided is going to be something that you can support, later in court. If you don't have witnesses and the witness signatures aren't notarized, then you can have a problem. You got to bring those witnesses into court. Are those witnesses still going to be around? Are those witnesses still from the state of Alabama? Are you going to be able to find those folks? In Alabama we have there's a self-proving will, and that's really what you need in this situation, right?
That's right, and that goes to kind of a more global point, Michael, and that is that you can get a will off the internet, and I think ChatGPT can do it faster than you and I can. I would think. But the question is that going to get you the best result for you and your family? And that's where, are you willing to take that risk? Is the answer yes or no? That's for you to decide. But what is the best possible outcome? And then are we going to get it through an online service provider? These are just things to think about.
Because assets, like a life insurance policy, some things have a beneficiary named, and those things won't even go through the probate process, right? Even if you write it in the will big as day, that may not be how it's going to go. And if you've drafted your will saying, you think and you put it in the will, that may not be how it's handled, right? The way things are titled makes a big difference.
That's exactly right. Beneficiary designations on things like bank accounts, life insurance policies, IRAs, 401ks, annuities, CDs, they trump whatever's in your will or trust, subject to some spousal inheritance laws. So it's very important to have a cohesive plan that's created with you, your spouse. Spouses' estate plans necessarily involve each other, and a trusted professional is a good idea too.
Yeah, I mean, you get in a situation where you can have property, you think you're handing it down, and you don't really, you've already done it, and given it to somebody else.
We've got callers waiting. We've got Rich on the line with a question from Gurley. Hi, Rich. Thanks for calling. What's your question tonight?
I want to ask a question in that I have a written will out of the state of Alabama. It's in Illinois. Okay, but I originally was from Illinois and I moved to Alabama. Me and my wife, and we finally got our license switched over to Alabama. And my question is, if something was ever to happen, I got a will in Illinois, would it be good in Alabama, or would a lawyer from Illinois have to come down here to get my wills all done?
Good question.
Yeah, that's got.
Does he need to do a new one?
You got a lot of things going on. One is, I think you're probably going to say he needs to do a new will if he's moved from one state to another. But in general, if you did a will in another state, is it going to apply in Alabama?
Yes, that's what I'm asking.
Yeah.
It's a great question, and it's a common one we get quite frequently. The answer is it's going to depend on the instrument. Living wills, which I think Richard mentioned, powers of attorney, advanced directives, things like that, are more likely to have explicit reciprocity in the statutes, meaning that if you executed it properly under Illinois law and you move here, it's not going to necessarily require a change just because you move to Alabama. However, With the will is more of a central document in the estate plan, so it might just be a good idea to revisit the plan and perhaps redo it, perhaps not, but that's just indicative that maybe it's been enough time and maybe there's been some law changes or some family changes that we need to just look at things.
Yeah, and, and if you've already got the basic structure in place, it's not incredibly expensive to go talk to a lawyer and get those documents revised, right?
That's correct. In a situation like that, Michael, we'd probably be talking hundreds, not thousands.
Yeah, good.
We got a text question. So we told you again, you can also text your questions to us now. We got this text question. I updated my will a few years ago. However, I need to delete a few things now. I recently found out that a codicil could be done instead of updating the entire will. So is that a good idea? What do you think about codicils?
Well, codicil is it's like one of those
fancy
legal
word.
words. It's a fancy legal word, and everybody says, "Whoa, we need to worry about this." So what is a codicil?
Sure. So a codicil is just a change to a will. It's an amendment to a will. And there's kind of two ways to change your will. I guess three. One would be to revoke it, put it in the shred box. Two would be to do a codicil. That's an amendment to it. I'm taking out a section, adding a line, something like that. And three would just be to do an entirely new will. All can work. Which tool is the best there? Kind of depends on the situation, but that's just what a codicil is. They're fairly straightforward, at least in regard to what they are.
Right, and that's what we kind of talked about this before the show. But if you're going to do a minor revision, a codicil is probably not a bad tool. If you're changing, maybe somebody's name or somebody's, because they got married, or somebody's address, or are making a deletion because of you've gotten rid of some property, something that's pretty clear, not likely to get contested. That's probably something. It's important. If you're leaving out a child or leaving out your spouse, then what do you want to do there?
Yes, a revisit of the estate plan is probably in order there, and kind of a very important point related to that is a will might not be the right tool there. If we have some planning needs and some planning desires like that, a will is just a tool, and it's an important tool, but in that situation, I can probably already go ahead and tell you the will is probably not going to be the right tool there.
Yeah. They're telling us take a break. We're going to take a break. We're going to come back and talk about, okay, so who can you write out of your will? Who can you disinherit? And who can you not? I know you want to know. Stick around. We'll be right back answering more questions about Grandpa and the law.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, attorney Heath Brooks, attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviet. Tonight we're talking about Grandpa in the Law. We're talking about estate planning. We've got with us Michael Timberlake from Timberlake, League & Brooks. We've got with us Zach Anderson from Valley Estate and Elder Law. And we've got callers with questions. We've got Chad on the line with a question from Huntsville. Hi, Chad. Thanks for calling. What's your question tonight?
Hey, Mike. Hey, Zach. Hey, how you doing, too? It's beautiful. I would like to know, is it better to get a trust or a will?
A trust or a will?
Yeah, that's a really good question. It's kind of like, there's two different vehicles. There's two different tools that you can use. A will passes, property, whatever, your assets once you die. But a trust can either, do that. It can be set up when you die, or can do that during lifetime. So what's the story? Why would you need what?
That's exactly right. Trusts are extremely customizable, Michael, so that's the first point. The question of trust versus will is one that I think I probably get at least once a day, and it really just depends on what your goals are, what your family looks like, and to a lesser extent, what your assets look like. So some of the markers for a trust being more appropriate to run the estate plan through rather than a will might be if you have a family member with a disability, if you want to leave things to people other than your spouse or your children, if you desire pretty significant privacy upon your death, and if you are high net worth, a couple other factors, but those are the biggest factors. Long-term care costs is kind of an interesting play there. That can be a marker as well. But those few things, if you hit those, you might want to look at a trust. If not, you may be okay with just a will.
Yeah, and then that's kind of, it's a good point. It's like, you want to do estate planning, and you're like, well, I'm not, maybe I just turned 50, and I'm like, I'm not looking like I'm going to go anywhere anytime soon. But at what point in your life do you need to start doing that?
As soon as you attain the age of majority in Alabama, which is 19, you at least need some really basic stuff. And I'm a big fan, just for the record, of legal technology empowering those who traditionally don't engage in estate planning to engage in it. I understand 19-year-olds generally don't think about it, myself included, when I was 19. But really, just some basic stuff when you're a young adult can go a long way.
If you got in a car accident and you're 19 and you don't have a spouse, or maybe even if you do, getting somebody to be able to make medical decisions for you, or to be able to handle your rent, or to take care of things for your expenses, so much easier if you've got a power of attorney or something, rather than forcing people to go to the court and get some kind of orders in place.
Yeah,
that's much more expensive.
Bad things can happen. We hope they don't. But when they do, you want to make sure that you've got the right plan in place.
Who can you disinherit? A lot of people think that you're entitled to, your parents are obligated to leave you their stuff. Are your parents obligated to leave you anything, or who can you disinherit?
And that's a weird question to ask on Father's Day.
On Father's Day. Do you have to leave your stuff to your sons?
Yeah, in Alabama, there is only one person that you cannot disinherit. Disinherit means I'm not leaving you anything. And in Alabama, that one person is your spouse. And even then, you can disinherit your spouse through some tools like prenuptial agreements, or a properly drafted and funded certain type of trust. But in general, spouse is the only person that Alabama says you can't write a will and say, I don't give this person anything. Children, that is correct. Children, grandchildren do have no inherent right under Alabama law to inherit anything. There's one kind of minor point I'd like to add, and that is that you don't have to leave anything to anyone. You can, and in many cases probably should, spend what you have on you and what's important to you.
Yeah, make it rain.
Make it rain. We've got Howie on the line with a question from Huntsville. Hi, Howie. Thanks for calling. What's your question tonight? You still with us?
Yeah, I'm 70 years old, and I own several rental properties, and I've recently sold them with owner financing, and I've taken back 30-year mortgages. I want to know, I keep everything in my name. I have it incorporated because I want to be able to represent myself in court. But if I have a will, can I leave it to my children Can the personal representative keep the estate open for 30 years while the mortgages are still going, then distribute the money that they get? Or is there a time limit they have to turn around and close the estate?
Gotcha.
Yeah, hey, that is a good question. And
Leaving
in
an
terms of
estate
like,
open 30
you know,
years sounds like a problem.
Yeah, I don't think that's going to be a thing that the court's going to allow. But in that situation, if you're the sole owner of an LLC, you're the sole stock owner in a corporation, and you pass away, I assume you could name a beneficiary in the corporation, and it would pass outside of the estate, or you could leave it according to a will, right?
Yes, that's exactly right, Michael. This caller perhaps indicated that maybe the assets were in his individual name and
I think
were
he said, yeah.
not
I think
in
he's
some
not
kind of
incorporated.
corporate entity.
Right.
So in that case, the assets would pass through the probate process into the name of the heirs or whoever was named that you in your will name, sir. And they would be subject to court proceedings and oversight, although it would not last 30 years. We would get them into the names of the beneficiaries within 30 years, but they would be subject, of course, to the mortgage, which I think is maybe the heart of your question, sir.
So you basically transfer the corporations over into the beneficiaries' names?
Yes, and here with rentals, it may not be a total inherent disaster, but I have had situations where we have small business owners that are more, maybe like they run their own law firm or something like that, and they've got to make payroll. And nobody can act for the estate until we get letters of administration or letters testamentary or something like that. And I've run into some really hairy issues. So remember, one of the markers for some kind of more advanced or more sophisticated estate planning is kind of variation of assets and net worth levels. And if you've got, multiple rental properties, probably a good idea to seek maybe a more sophisticated level of planning for those assets.
Okay, got a text. I'm a personal representative for an estate. The children don't want this, but this person was and still is, if the children are opposed to somebody being named as the personal representative, what can be done about that?
Yeah, so that's a great question. So if somebody dies in Alabama without a will, there is the statutory the scheme sets out who's the personal representative. The surviving spouse has priority, and then you would look towards basically any resident of the state of Alabama could qualify. Now, anybody that's a beneficiary or a potential heir of the estate has to have notice before a personal representative is appointed. But if there's no will, then it can be basically anybody if the surviving spouse lets that 45-day period run. Now, if there's a will, there's a specific designation, right?
That's exactly right, and it's going to be difficult to attack, and that is by design of the law. If you name someone as personal representative of your will, unless there's malfeasance, they start taking assets for themselves and committing crimes and doing things like that, they're going to serve as personal representative, and that's the reason we have that. It's to put you in control of your estate when you do the will. Otherwise, anybody could attack it and it would be undone, and there wouldn't be a whole lot of point then.
Yeah. And the representative can get paid for it, but typically the representative, if it's not a family member, may not be a beneficiary of the will. It can be completely independent third party or just Aunt Jane that's somebody trusted to do right.
Detail oriented.
Yeah, exactly.
Detail oriented Aunt Jane. We got this question. Okay, how do I disown a person in Alabama? How do you do that? So if you don't want to leave something to your child, how do you disown them?
There are multiple ways you could do it. You could do it through a will, through a trust, or even through a beneficiary designation, just by having someone else as the beneficiary of that asset, like we talked about earlier. If we're talking about doing it in a will or trust, which I suspect our texter is getting at, it's best to be clear what we're doing and say, I am not leaving Sally Smith anything. She is a natural heir of mine or something to that effect. I'm deliberately not including her as an heir. We don't have to be mean about it. We don't have to
tell her exactly why. I'm going to tell you why.
You sell that part, right? That's the book portion.
That's
so
right.
If it's a child and you don't say the child's name, if you just don't mention it at all, that's a problem, right?
Yeah,
You
almost
got to
certainly.
say, you got to say the name, and you got to say you are disinheriting. You don't have to say why though. Okay.
Yeah, I mean, even the laws really favors inclusion of heirs, and so if you had to my son Billy and to my daughter Jane, I'm leaving my estate to them totally, and you had another child after your will, what's the court going to do with that?
Yeah, so that's a really important reason to have after born or after legally adopted children included in the language of your will or trust. That's kind of a higher level point. I'm really glad it was brought up. So ideally, your estate plan catches that through smart drafting and smart counsel and things like that. If not, probably, I don't want to say probably, you might be okay under the statutes, but I would not take a chance on that.
Right.
Where do you tell people to keep these documents? So where do you tell people to keep their will, where to keep the powers of attorney? Do you lock them up in the safe deposit box, or what do you tell people to do with it?
I don't personally love safety deposit boxes. They are sealed upon your death unless there's a joint owner. I love fireproof safes. I understand that is cost prohibitive for some people. Having a good digital copy on a cloud-based system with a password that's handled the way that you want it to be handled is a great backup. We can sometimes run with a copy of the will even if we get the original misplaced or something like that.
Somebody has called in, they didn't want to go on the air though. They said, what if my lawyer that drafted it retires? Is that a problem? If the lawyer, and that's going to happen a lot of times, right? Because many times.
Depend on why he retired, right?
Okay, if there's a problem.
No, in general, I mean, it happens all the time. You don't rely on your lawyer to keep your estate documents. You rely upon your lawyer to create your estate documents, give them to you, explain why they're important and what they'll do, but they are your documents and you need to keep them in a secure place.
And they're telling us take a break. We'll be right back. If you didn't get your questions answered tonight, here's how to get in touch with Zach Anderson with Valley Estate and Elder Law in Huntsville, 256-273-5109. Also check out thevalleyplanning.com. If you need to reach Michael Timberlake with Timberlake League and Brooks for personal injury cases, that's car accidents, medical malpractice, 256-536-0770 or 800-804-2502. The website is law-injury.com, and you can like them on Facebook and learn more about the law that way.
And Sharon's a fantastic family lawyer. She practices here in Huntsville and all over North Alabama. You can find her at SharonFamilyLaw.com.
Thanks for all your questions. We'll see you next week.